I'm Joel Eisen, professor of law at the University of Richmond School of Law, and this is the Synopsis. Before the end of this spring term, the Supreme Court will issue decisions in 3 cases that involve federal administrative law. And these decisions, working together, have the potential to seriously undermine the work of federal administrative agencies. In fact, you might think of this as a 3-pronged attack on the administrative state. The first one is Loper Bright versus Raimondo. On the surface, this case is all about fish. Can a federal agency make the fishing industry pay for monitors aboard their boats that are there to prevent overfishing? But there's a much larger principle at issue in Loper Bright. It's called Chevron deference, under which courts uphold federal agencies' decisions if they make reasonable interpretations about statutes that fall under their purview. Here's how it works. Congress passes statutes that direct agencies' actions, but those statutes leave room for agencies to fill in the details. So in almost everything that they do, agencies are interpreting these statutes to fill in the gaps. Well, that happened here. The statute explicitly provided that fishing boats had to carry monitors on board to make sure that they weren't overfishing. But it didn't say how the monitors were going to be paid for. The agency decided that industry should pay for the monitors. And under the Chevron doctrine, this interpretation of the statute would gain deference. The courts would defer to the agency as long as its interpretation was reasonable, as long as the statute didn't clearly say otherwise. And that is, in fact, what happened here in the D.C. Circuit Court of Appeals. Now, in Loper Bright, the Supreme Court may overrule Chevron, and that would give courts more of a say in deciding what the statutes mean. Well, there's a bit of an irony here. 40 years ago, when I was a law student taking the administrative law course, Chevron was first decided. And some of the concern there was that courts would no longer be able to decide what the law meant. There would be deference to agency positions as long as they were reasonable. It sounds logical to have courts deciding more what the statutes mean. But often agencies have expertise that the courts do not. Here, we're talking about an agency, the National Marine Fisheries Service, or NOAA Fisheries, that has decades of experience deciding how fish are caught in the waters off of New England. There's a 400-page plan for the fish called the Atlantic herring that decides how many fish can be caught, when the boats can go out, and other matters. To have a court decide matters like this and how the monitors are paid for would upset decades of settled administrative law. Chevron is one of the most cited cases since it was issued 4 decades ago. And what would happen if courts had the power to decide what the statutes mean is that agencies might be reluctant to make new policies. In fact, there would be a threat to hundreds of cases that are pending now in the lower courts where the Chevron doctrine is cited as a precedent. But that's only one of the 3 cases we need to talk about that are upcoming that pose a threat to federal administrative agencies. Our next case is SEC versus Jarkesy. An administrative law judge at the Securities and Exchange Commission found that hedge funds established by George Jarkesy committed securities fraud. The Securities and Exchange Commission fined him and barred him from participating in the securities industry. But rather than pay that fine and not participate in the industry for several years, Mr. Jarkesy challenged the findings of the administrative law judge. In fact, he brings a challenge to the entire process by which the SEC does adjudication, by which we mean judging by administrative agencies. He brings 3 challenges. The first is that instead of his case being heard by a single administrative law judge within the agency, he should have had the right to a jury trial under the Seventh Amendment. Second, he claims that the administrative law judge was unconstitutionally appointed. That is, the judge got their job in violation of the Constitution. And finally, he claims non-delegation. That is, that Congress had not given the power to the agency to make this sort of decision. Let's take that middle claim first. It rests on an interpretation of the Appointments Clause of the Constitution. The matter of whether particular federal employees have secured their positions properly under the Constitution has been a matter of some discussion and litigation all the way to the Supreme Court in recent years. Here, Mr. Jarkesy claims that because of the responsibilities that these judges take on, the ability to decide whether somebody like Mr. Jarkesy has committed securities fraud, that this judge has to be appointed by the president and confirmed by the Senate. Now, this is an argument that has been present in several Supreme Court cases over the past couple of years, but if it succeeds in this one, it could overturn the administrative law judge's ability to make independent decisions within their agencies. If these judges were answerable to the president for every decision they made, this might pose a real challenge to their independence. But at the Supreme Court oral argument, the big focus was on the right to jury trial. And if the Supreme Court were to decide that cases of this sort had to be heard in federal court by juries, that would pose a much greater challenge to decision-making at administrative agencies, for there are thousands of administrative law judges in all federal agencies, and their decisions would immediately be subject to review in the federal courts. And that would pose a serious challenge to administrative law judges' ability for independent decision-making. The third case is called Corner Post versus Board. In this case, Board is the Board of Governors of the Federal Reserve System. The underlying regulation that's at issue involves debit card swipe fees. They're called interchange fees. And this rule puts a cap on how much a merchant can be charged by a bank for allowing you to use a debit card. Sometimes these fees are passed on to you, sometimes they're not. The rule sets a cap for how much a merchant can be charged for these interchange fees. This rule has been settled for more than a decade. Corner Post is a truck stop in North Dakota. It's a member of an organization of retailers. It seeks to reopen and challenge the entire rule, not the rule as applied to it, but the entire rule. It believes, like all of the retailers involved that have to pay these fees, that these fees are too high. This case involves the intersection of two different federal statutes. The first is the General Federal Statute of Limitations. You have 6 years to sue the United States. If that 6 years runs from when the rule was made in 2011, then Corner Post's lawsuit would be barred. But there's a second statute that Corner Post points to. It's the Administrative Procedure Act. Section 702 of the APA allows a suit by a person against an agency who has suffered legal wrong. And Corner Post says that it was incorporated in 2018, and therefore the 6 years that runs against it under the statute of limitations has to run from when it first had the ability to bring this lawsuit. And that would be in 2018. Now, this may sound like the technical intersection of two very wonky and complex federal statutes, but in reality, the consequences here could be enormous. A holding for corner post might subject agencies to endless litigation by new business entrants. All an association would have to do is find a company like Corner Post that had just recently been incorporated and have them bring the lawsuit. Any federal rule by any agency would be subject to this type of challenge given a holding for Corner Post here. Think about how these three decisions work together. They have the potential to seriously weaken the ability of federal agencies to protect the environment, consumers, and investors by making it easier to sue agencies in federal court, and changing the level of deference or respect for the interpretations of agencies once we're in the federal courts. I am deeply concerned about this attack on the administrative state and looking forward to the decisions in these three cases.